So let's just imagine a file. It's on a desk somewhere, and it has a big, bright red stamp on it that just says closed.
And when we say closed, we mean really closed. This isn't a maybe.
Right. This file is for a prisoner who's hit every single dead end. The High Court appeal was lost. Supreme Court lost.
Even the mercy petition to the president was rejected. For all intents and purposes, the only thing left is the execution.
And yet, the reason we're doing this deep dive is because in the Indian legal system, closed might not always mean what we think it means.
Exactly. We're looking at the 2025 landmark judgment, Vasanta Sampat Dupare versus the Union of India, and it just completely turns our idea of finality on its head.
We've got the judgment here, and our mission is to figure out how the Supreme Court justified cracking open a death penalty case that everyone thought was, well, finished.
It all comes down to a collision, really, a collision between two huge legal concepts.
Okay.
On one side, you've got finality of judgment, the idea that cases have to end at some point.
Right.
And on the other, you have Article 21.
The fundamental right to life.
It doesn't get bigger than that.
Now, before we get into the constitutional weeds, we need to ground this. Because this isn't, some abstract legal debate.
No, not at all. The moral weight here is just immense. The crime that Dupare was convicted of was the rape and murder of a 4-year-old child in 2008.
So the brutality of the crime is not in question here. The guilt is established.
Absolutely. The court isn't re-examining the crime. It's re-examining the punishment.
Because something significant changed between his sentencing and today.
A lot changed. But the big one was in 2022 with what we now call the Manoj guidelines.
Ah, right. These are the rules that mandate a comprehensive psychological evaluation, background checks, before a death sentence can be handed down.
Precisely. The court basically said you can't decide to take a life without fully understanding the person you're sentencing. But Dupare was sentenced years before those rules existed.
He never got that evaluation.
Never. So his lawyers argued that executing him now would be arbitrary. It would violate his fundamental rights. And the Supreme Court, remarkably, agreed.
And they used Article 32 to do it. That's usually for enforcing rights, not reopening a finalized case.
They called it a continuing safeguard. Their logic was that the death penalty is totally unique. It's irreversible.
You can't undo it.
You can't. So they said that finality in this one specific context cannot triumph over fundamental rights.
Okay, but it still feels like changing the rules after the game is over. How do you apply 2022 rules to a 2008 sentence?
This is the really fascinating part. They leaned on a legal concept called the Blackstonian theory.
Oh, the declaratory theory of law. I love this. It's the idea that judges don't actually make new law, they
discover it or declare what the law always was deep down.
So if the Manoj case said fairness requires a psychological evaluation.
The Blackstonian view says that fairness always required it. The court in 2022 just finally articulated that principle. The right was always there. It was just dormant.
Wow. So the protection isn't new, which means it can be applied retrospectively.
And that's the logic. The court is making a statement that the Constitution's majesty lies in its restraint, not just its power.
Now, we have to be extremely clear about what this means. This judgment does not mean Dupare walks free.
Absolutely not. That's a crucial distinction. The conviction for that horrific crime stands. He is still guilty.
So what did the court do?
They only set aside the death sentence. They've ordered a fresh hearing to decide the punishment, but this time it will be done according to these modern, rigorous standards.
It's a procedural reset on the sentencing phase only. So for legal professionals listening in, this is huge.
It's a massive signal. It means compliance with sentencing guidelines is non-negotiable, even for cases you thought were locked away.
And for you, the public, it's a profound civic lesson. It shows that the system, at its best, values fair procedure over quick closure.
Even for the most heinous crimes, the ultimate punishment can't be arbitrary.
But it forces a really difficult conversation, doesn't it? We're talking about the convict's right to a fair process.
But on the other side?
On the other side is the victim's family. It's been nearly 2 decades since the crime. They went through every court. They thought they had closure.
And now they don't.
And that's the thought we want to leave you with. If the legal process for the ultimate punishment can never be truly final, because our understanding of fairness evolves.
Can a victim's family ever truly find closure?
It's a heavy question.
It is.
Thanks for diving in with us.